Welcome to the Judicial System Podcast. Through this podcast, we will be covering the judicial system of the United States. The power of the judicial system lies within its power of judicial review. Judicial review is the power of the courts to declare laws and actions of the government as unconstitutional. This is where the ultimate power of the judicial system lies. Now, we previously walked through the power and the responsibilities of the legislative and executive branch, and today we will be walking through the power and responsibility of the judicial branch. But first, in order to accurately understand the powers and responsibilities of the judicial system, we first have to understand its structure. The U.S. judicial system can be broken down into two parts. The first part is the federal court system. The second part is the state court system. In our unit today, we will be focusing on the federal court system. The federal court system can be broken down into three parts. The first part, or the first layer, is the federal district courts. The second layer is the Circuit Court of Appeals. And the third and final level or part is the Supreme Court. And as this diagram suggests, the federal court system is actually divided among a series of power. The first level of power resides in the federal district court, and that has the least or lowest amount of power in the federal court system. And the top or third level of power lies within the Supreme Court. The Supreme Court has the most power within the federal court system. So let's break apart each of these different layers within the federal court system. The first layer, as suggested, is the federal district courts. The federal district courts are comprised of 94 U.S. district courts within the nation. These 94 district courts are divided among the states within the nation. And the number of U.S. district courts within each state is decided upon based on population. For example, Wisconsin has 2 U.S. district courts within the state, while California has 4 U.S. district courts within its state. This suggests that the amount of district courts within a state is determined by the number or population of individuals. Now, the number of judges which hears a district court case is equal to 1 judge. Now, there's 1 judge which hears 1 case, or is it within that 1 U.S. district courtroom, but the judge is also accompanied by a jury as well. The federal district courts are trial courts in that they hear original jurisdiction. Original jurisdiction is the fact and the matter that these courts hear the first case, the case for the first time. They see the evidence for the first time, and they hear both sides of the issue for the first time. They have originality in being the first to see a case. Furthermore, these types of cases include civil and criminal cases. So the second level or layer is the Circuit Court of Appeals. To appeal something first means to resort to a higher authority. Secondly, to appeal something means to request for a new hearing. If an individual is not satisfied with the decision made, perhaps at the U.S. District Court level, they can request for a new hearing to a higher level, or to the Circuit Court of Appeals. Contrary to the U.S. District Court, the Circuit Court of Appeals has appellate jurisdiction. Appellate jurisdiction is a court's authority to hear a case that has already been heard by a lower court. The Circuit Court of Appeals is comprised of 13 U.S. Circuit Court of Appeals. These 13 circuit courts are divided into 12 regional courts throughout the nation, and the 13th lies within Washington, D.C. Circuit court cases are heard or judged by a 3-judge panel. There is no jury within a Circuit Court of Appeals court case. Rather, only 3 judges at a time examine a Circuit Court of Appeals case. The cases heard at this level are cases in which individuals are dissatisfied with judgment of the U.S. District Court. The exception to this rule are criminal cases in which defendants are found not guilty. At the U.S. Circuit Court of Appeals, individuals examine the records for mistakes of law. Rather, they don't look at new evidence or new facts, but the judges simply examine whether laws were adequately applied or considered in previous court decisions. Again, they will not review facts of a case or any new evidence, but rather just look at the facts and information provided by the lower court systems. So let's further look at the differences between trial and appeal courts. First, in a trial court, two parties present a side and evidence to be examined by a judge and a jury. Contrary, in an appeals court, cases are presented to a panel of 3 judges, no jury. In a trial court, we have cases which affect only the people involved in the case. While contrary, in an appeals court, cases can affect a large group of people because decisions are binding to a district. In a trial court, cases are heard for the first time, again touching upon this issue of original jurisdiction. While in appeals courts, there is no new evidence, but judges simply review materials from original trial and application of the law. Let's look at a map of the District and Court of Appeals locations within the United States. So again, what this map shows is the location or division of U.S. District Courts within the U.S., and also the locations of the Circuit Court of Appeals throughout the U.S. So as you can see, looking closer at Wisconsin, there is the western part of the state and there is the eastern part of the state. And these actually show where the two different district courts would be within Wisconsin. The one district court would be within the western half of Wisconsin, while the other would be in the eastern half of Wisconsin. And those two district courts would examine jurisdiction within those two parts. Furthermore, these larger numbers demonstrate the Circuit Court of Appeals throughout the United States. As you can see, number 7 indicates the Circuit Court of Appeals, which would apply to Wisconsin. And it also shows, if you look further down the map, actually it's not there, but the color coordination of the states indicate where those states would be directed for the Circuit Court of Appeals. So all these states in blue would actually, their jurisdiction in terms of the Circuit Court of Appeals would fall to this number 9. So I just wanted to show you that map in order to guide you into understanding where the District Court and Appeals Courts would fall within the United States. But let's continue on in investigating the different courts in the federal courts. So now that we've covered the first 2 layers, the federal district courts and the Court of Appeals, let's move on to the court with all the ultimate power, or the Supreme Court. The Supreme Court lies within Washington, D.C. It consists of a panel of 9 judges, and the Chief Judge presides over the 9-judge panel, and that judge is known as the Chief Justice. The cases within the Supreme Court are court cases in which parties are not satisfied with the decisions of the U.S. Circuit Court of Appeals, or in the rare cases, the U.S. District Courts, and also the decisions made by state Supreme Courts. So if an individual is dissatisfied with the decisions made by any of these 3 courts, they can petition for their cases to be heard by the Supreme Court. In order for a case to be heard by the Supreme Court, they must go through the following process. First, an individual or someone that would like to have a Supreme Court hear their case must send a petition to the Supreme Court. This petition is in a way in order to get or gain a writ of certiorari, or a way in order for the Supreme Court to grant the permission to hear a case. Once a petition is sent, the judges examine whether to hear a case. For every 7,000 cases sent or petitioned to the Supreme Court each year, the court only accepts between 100 and 150. So a petition is an attempt to get a case on a docket. A docket is a list of cases considered by the Supreme Court. In order to get on this list or the docket, a petition must include a brief, which is a written statement setting forth the legal arguments, relevant facts, precedents, and supporting one side. And in terms of precedents, the petition must also include an explanation of prior judicial decisions which support the side of the argument. Now, if the justices agree to hear a case, 4 of the 9 justices must agree in order for a case to be granted a writ of certiorari, or a review of the case. Now, at this time, I ask students to think back to their prior knowledge and consider what kind of professional preparation should Supreme Justices have. Now, if you would like to take a break at this time and pause the video, or just think about what kind of professional preparation a Supreme Court Justice should have. If not, let's continue on. Furthermore, I had students participate in the following activity. I had students read the above quote from the U.S. Constitution, Article 3, Section 1. And based on the excerpt above, what do you think are the qualifications of the Supreme Court Justice? Record your answer either on a piece of scrap paper or simply hold it in your head. Take this time, brainstorm, think about, according to the Constitution, what are the qualifications of a U.S. Supreme Court Justice? Are you thinking? Are you thinking? All right, I'll tell you the answer. There are no official or formal qualifications of a Supreme Court Justice in the Constitution, but rather there are a series of criteria used by the President in nominating a Supreme Court Justice. Now, as previously noted, a Supreme Court Justice is nominated by a President. It is later approved by the Senate. But in nominating a Supreme Court Justice, the President uses a variety of criteria. The first being that they try to nominate someone with competence and ethical standards. They want someone to represent our government in an intellectual way and with good morals and good standings. Furthermore, a president will nominate an individual who has some judicial experience. Now, as you could previously see in the quote from the Constitution, a nominee or a Supreme Court Justice does not have to have background in judicial experience, but a president tends to pick someone with that experience or with that background so they can do their job effectively. Furthermore, a Supreme Court nominee tends to have the ideological and policy preferences of those of the president. Nominating a Supreme Court Justice is a once-in-a-lifetime opportunity for a president. Thus, they will pick someone who agrees with them in policy terms in order for the president's policies or ideas or opinions to get passed on throughout the U.S. Furthermore, a president will nominate someone as a Supreme Court Justice nominee as part of a rewarding of their political friends and allies. So they will be doing a nomination in honor of that individual, maybe supporting them through their presidential campaign. Furthermore, a president may nominate an individual in order to increase his or her own executive powers. A final criteria used by the president is diversity. Being that America is comprised of a diverse mix of individuals and ethnicities, presidents tend to nominate individuals which recognize or acknowledge those diversities. At this time, this is the end of part 1 of the Judicial Branch podcast, and so I encourage you to go find the second half. See you later.